to the June South Florida Bloggers Meetup. How are y'all today? Awesome, I'm so glad you're here. I'm Paola Mendez. I'm the founder of the Blogger Union and the South Florida Bloggers. I'm really happy to see you all here today. Oh, and I also run Programs as well. Alright, so today we will be talking about trademarking, how to protect our brand, and it's really exciting. I have so many questions for our speaker today. Alright, our speaker today, she's an attorney and co-founder and managing partner of a law firm called Minott. They specialize in intellectual property and trademark law. She started a website called flatfeetrademark.com, which I'm going to describe as the Uber of trademarking. Is that true?
I never thought about it like that, but okay.
Where you can get affordable flat fee trademarking services from experienced attorneys. She's been featured in the New York Times, Entrepreneur Magazine, and the American Bar Association. Can you please welcome Serena Minott?
Happy to be here with you guys today. Thank you all for coming. Thank you all for taking a semi-sunny Saturday to listen to me talk about trademarks and to answer your questions. And I appreciate Paola for inviting me to come speak to you guys today. So as she said, my name is Serena, and I am the founder of Minott Law. It's a trademark and business law firm here in Miami. And in 2008, we launched Flat Fee Trademark, which is an online trademark registration service for clients in South Florida, nationally and internationally. I've been practicing trademark law for 12 plus years now, and I'm kind of a brand nerd, so even before I was doing trademark law, I've been obsessed with like brands and billboards and signs, and when logo changes, I'm like, oh, so does it change their logo? Like, I'm totally a brand nerd that way. So you guys still hear me okay? Yeah? Okay. Alright, so a little bit about who I am besides what I do. I'm a mom to a very active 3-year-old toddler, and I'm a wife and a trademark attorney. In my business life, what I do is help individuals, startups, entrepreneurs, and companies to protect their brand names. Now, what does that mean, right? So let's get into the details. What's a trademark? Do you have a trademark? Is this conversation even relevant for you, right? So let me just get a gauge of who all in the audience already has their blog up and running. Pretty much everybody? Almost? Okay. And have any of you gone through the trademark process or applied for trademark registration? Okay, I see one hand. What's your trademark?
I don't use the logo yet until I receive the approval for the application.
Okay, what's your mark?
You mean like the name?
Yeah.
Modeswear. Modeswear.
Modeswear. Okay, great. So that's a trademark, right? Your trademark is your unique identifier in the marketplace. That's how your customers, your clients, your readers, your followers know how to find you in the marketplace. If you go to the pharmacy, it's how you know to buy Crest toothpaste versus Colgate. If you go shopping, it's how you know to buy Louis Vuitton versus Chanel. Those are your trademarks, and they're important because that's how customers find you, right? If you were to change your brand name for whatever reason, you then have to rebuild all that goodwill that you've established in your existing name. So that's a trademark, kind of I'll get more into that. But as a starting point, just because you have a blog doesn't mean that you have a trademark, right? So this talk may not be for everyone. Now, when we first start off, we're just kind of like plugging away on our computers, right? We're like writing, and a lot of times it starts off as a hobby. You may not have a trademark, and this may not be relevant for you. But there are many, many bloggers who have built businesses out of their blog, right? You may start selling products, you may start offering services, and that's where the value of your trademark comes into play. For example, I just today met Shahida. I asked her if I could use her blog as an example. She has a blog called The Deutsche Diva, and she does language learning and language support for people who are learning languages, specifically English and German. And it could be that one day she launches a language learning software, or she may have a series of books or workbooks that she launches around that brand. So her trademark would be important because she wants to protect her brand name, the Deutsche Diva, in connection with whatever products or services that she starts to offer. You all are probably familiar with some popular bloggers who have then become kind of brand names or brand personalities. Can you guys name a few that you know and that you follow? Fashion poet.
She did her own now clothing line.
Okay, so she went from being a blogger to having a clothing line. You all are probably familiar with Man Repeller, or The Sartorialist, or Lindsay Calla from Saucy Glossy. She now has TJ Maxx advertisements. I wouldn't be surprised if she now has her own clothing line. So it's very, very possible for someone who is a blogger or a writer to then launch into selling products or services in connection with that brand. So that's why, it's kind of relevant for you as writers, even though sometimes it feels like you're just plugging away on your computer and just, kind of putting your thoughts out to the universe, why your trademark may be important to you. So now that we've determined whether or not you have a trademark or may have a trademark, let's dig into, taking one step back. What is a trademark, right? So we said it's your unique identifier in the marketplace. Some very popular trademarks you guys might be familiar with, you encounter them on a daily basis. Apple, Google, Facebook, Starbucks, the most famous and valuable brand in the world. Can anybody name the most famous valuable brand in the world? Coca-Cola, who said it? Yeah? Okay. $80 billion, and that's just the brand. That's not the bottling facilities, that's not the product, that's not the trucks that deliver the actual, products. That's just Coca-Cola brand, 80 billion with a B. So trademark, needless to say, can be very, very valuable, depending on what you're doing and how you, protect your mark. So that's a trademark. What makes a good trademark? Right? The ones that I named, Google, Facebook, Coca-Cola. These are marks that you never heard of until you saw them in connection with these products, right? So in thinking of a good name for your blog, for your products, for your services, you want to think of something that's unique, distinctive, and often what's called arbitrary or fanciful, right? So no one had ever heard of a Google until Google came up with that name for their brand name, right? So that's a fanciful trademark, something you make up out of thin air. My company, unfortunately, is called Flat Fee Trademark. Now, it's a great name for search engine purposes, but it's very, very difficult to enforce because it's descriptive. It tells you what it is. I do trademark on a flat fee basis. So that's not a good example of a trademark. That's a weak trademark, to be quite honest, but it's effective for us for purposes of our business. So in picking your trademark and a strong brand and a strong mark, you want something that's distinctive, unique, and generally unheard of before. Perfect example, yesterday I did a trademark search for a client that wanted to do a line of watches. We went through 5 different marks before he could find one, but he was picking very common words: heritage, legend, DNA, especially for jewelry, clothing, accessories. These are trademarks that everyone has a line for, so there are tons of trademarks in those areas. So you want to pick something that's unique and generally probably never heard of before. I thought her mark was genius, the Deutsche Diva, because it tells you a little bit about what she does. It's German, and also it's, kind of, she's a woman, so it kind of has that aspect to it as well. So I thought that was a really nice brand name. So that is how to pick a strong trademark. We've done thousands of these. I've seen a lot of good trademarks, and we've seen a lot of bad trademarks. So that's how to pick a name that's strong and that would resonate in the marketplace with your audience. And that's also important as well, right? You want something that resonates with your audience. So once you've determined that you have a trademark, and what is a trademark, how do you go about protecting your trademark name? There's only one hand that went up when we talked about trademark registration, and it was a woman in the back with her brother. The first thing you want to do, and let me take one step back also, a common question I get, and you all may already know this, is what's the difference between a trademark, a copyright, and a patent? So trademarks, as I said before, are for your brand names, right? So your Coca-Cola, your Google, your Facebook, your Starbucks. Copyrights protect original authorship. You're all writers here. Oh, in the middle here? Sure. So copyrights protect original works of authorship. So if you've written a book, or if you've written a song, I use the mic? Okay. I'm getting some back. Hello? Okay, looks like there was some background noise, so maybe I will go ahead with the microphone. So I would say yes, and so your trademark is your brand name, right? Your Google, your Starbucks, your Facebook, your Apple. The copyrights protect original works of authorship. So if you've written a song, or you've written a book, photography, artwork, these are original works of authorship that are protected by copyrights. A patent protects original inventions. So there has to be a piece of equipment or a device tied to your invention for you to get patent protection. And so that's the difference. A lot of clients call us, they say, well, I need a copyright. It's like, no, actually what you need is a trademark. So for you all, if you're writing a book, an ebook, or maybe even your blog content is subject to copyright protection, that's separate than the name of your blog, which is going to be your trademark. So that's the distinction there between those three areas of intellectual property. All three very valuable aspects of your overall brand portfolio and intellectual property. Questions?
Just cover the name of a blog? Does it also cover your images as far as your logos are concerned?
Right.
Or anything associated with your blog, colors, right?
Okay, great question. So her question for all those who couldn't hear is, does your trademark protect also your images and things of that nature? If you have a logo that is a unique identifier, right? Initially I said a trademark is a unique identifier of your products or services in the marketplace. So anything that does that in connection with your brand is a trademark. That could be, if you think of the Nike swoosh, that's a stylized image or a logo mark, that's a trademark. The word Nike is a trademark. The slogan, just do it, is also a trademark. Burger King, same thing. They have Burger King, they have do it your way or just your way, have it your way, I'm sorry. And that's also a slogan, trademark. All of them are trademarks. Now the images you use on your website, that's a different thing. If you take your own photos, for example, those will be protected by copyright. So when we talk about your trademark, it's strictly the unique identifiers, your brand, your logo design, your slogan, any kind of icon, you know, the polo horse, the Nike swoosh, the Brooks Brothers kind of two hanging pigs. Those are all unique trademarks when we talk about trademarks.
Do you have to file like separate trademarks for your name versus your logo, or can it all be covered under one?
Right, so I'll get into that a little bit when we talk about the process, but those are all unique marks. And so when you submit a trademark application, as I'll get into in a few minutes, you have to submit each one separately, and I'll get into the reasons why you do that and based on how you use your marks and why that would be important. So now that we've kind of talked about the three different types of intellectual property, right? Trademarks, copyrights, and patents, that's just a kind of background for you to know exactly what the different aspects of your portfolio look like and how do you protect each one. So the first most important part of the trademark process, so we've talked about whether you have a trademark, if this is even relevant to you, and what is a trademark? How do you protect your name in the marketplace? We're talking federal trademark registration. That's what my company does. We do it on a state level as well, but to be honest, a state trademark is not that valuable because it doesn't give you much more protection that you would have just by using your trademark. So what we're talking about today is federal trademark protection for your brand name. And what does that mean, right? That means that you would have nationwide presumption of ownership in that name. So the woman in the back that's protected her trademark, she said she has a sportswear line. So you would be the only person that can use that name in connection with your products, right? If someone else tried to use that name or something very similar, she would be able to send them a cease and desist letter or sue them for trademark infringement because she's taken that proactive step of protecting her name. So when we talk about federal trademark protection, it's to create that presumption of ownership in your favor for those products or services. L'Oreal for cosmetics, Express for clothing, Starbucks for coffee, right? So you can have a name, two marks to coexist in the marketplace as long as the products or services are different, right? We have Dove soap and Dove chocolate. There's Delta Airlines and Delta faucets. So as long as what you're doing is sufficiently different, you can coexist in the marketplace, but you start getting into some gray areas, right? If you make clothing, your name can't be that similar to someone else who sells clothing because it's too similar. The standard that you need to think about when you first start the trademark process is a likelihood of confusion. What does that mean? Would the average consumer in the marketplace encountering two marks in the market think that they are the same source? So if I went to the pharmacy and I saw Crest toothpaste or Super Crest toothpaste, I would think, oh, these are both Crest. So that's the likelihood of confusion standard. Would I be confused to think these products are coming from the same source? And so when you search your trademark, the first and most important step, because you want to make sure the name that you're looking for or trying to use or using is not already in use or registered or pending by someone else. So you start the process with a trademark search. I saw a question go up in the back before I get into searching.
Charges per good or service that you choose, and I just chose, for example, clothing, fitness clothing specifically. And so someone can put the name, use the same name for shoes, because I didn't pick shoes in the goods or service.
Right. Great question. So we talk about the likelihood of confusion standard, right? Wearable items tend to be, first of all, that's all covered in the same class. So even if you didn't specify footwear in your application, clothing, footwear, headwear, outer apparel, these are all, even jewelry and leather goods, these are all within the sphere of something that a clothing creator could create and sell. Great question, and I'll get into the different classifications once I get kind of into the actual application process. But to answer your question, and for those of you that didn't hear, she was asking if she didn't specify certain things in her trademark application, is she protected for those things? And the short answer is it depends. Like I said, even if you didn't specify footwear in your application, it's closely related enough to clothing where someone else would not be able to use or register your same mark for clothing because for footwear because it's too similar to clothing. But if you didn't register for water bottles, for example, someone could possibly register for water bottles because those aren't necessarily two things that you would think they go hand in hand. Now it depends. If she's doing sports, fitness and sporting apparel, possibly because a lot of companies that make sports attire also make sporting goods. So it really just depends on the overlapping services and how related they are. Based on what you're offering and what someone else may be offering. But if you don't apply for a category, you're not necessarily protected in that category. Yeah. So we could start with the trademark search. So to do your trademark search, right? I said that's the most important step to start the process. Why is this important? Anybody can tell me why it's important to start with the search? Exactly, right? You want to make sure the name you're using or plan to use is not already in use by someone else. Because if you start using someone else's trademark, you're probably going to get a cease and desist letter from them. And if you apply to the trademark office is going to shut you down.
One word is used. For example, mine is Squirrel Wine Consulting. I searched squirrel, which is what you want as a wine blog. And but squirrel apparently is a well-known company of some sort. So if you take that, that's why I added my consulting. Am I okay with that one word? Sure.
Yeah, that comes into question back to what we talked about, the likelihood of confusion standard, right? So the way trademarks work, because it's a likelihood of confusion standard, if you can't add one word to someone else's trademark and then use it because it may not get you past that threshold. But it depends on what the word is. So if you are doing, I didn't quite hear the word, squirrel? Swirl. Swirl. Okay, so if you wanted to do swirl consulting, was that the second word? Wine. Okay, so if you want to do swirl wine consulting and someone already has swirl for wine, that's too similar. Reason being, the words wine and consulting are descriptive. So I talked earlier about my trademark being flat fee trademark. It tells you what it is. The words wine and consulting are descriptive words. They don't have a lot of trademark value. You cannot register or protect a trademark that's descriptive. Similarly, you have to disclaim any part of your mark that's considered descriptive. So if you were to submit a trademark application, for example, for Swirl Wine Consulting, the trademark office is going to require you to disclaim those two words, wine and consulting. And so the core, what they call the most dominant part of the mark, is that word swirl. So if someone already has that for related goods or services, you could get a refusal at the trademark office. So that's another aspect as far as picking a strong mark. You have to think about the entire mark and not just how it's, not just the entire mark, not just one portion of it. Which brings me back to the searching, right? So we said to first start with the trademark search to make sure the name you want to use is available for use or registration. So what does that mean? Okay. You have a trademark for Swirl Wine Consulting. You have to look in, let me backtrack, I'm sorry. There's a couple different ways to search your marks. I said you first have to start with a trademark search. There's a couple different free resources that you all have to take advantage of if you have any interest in doing your trademark. You can use the Trademark Office. They offer a free search tool on their website. It's called TESS. That's the Trademark Electronic Search System. It's completely free. It's on the USPTO website, and I'll email all this information to you all separately. USPTO.gov. That's the US Patent and Trademark Office website. They offer a free search tool on the website where you can plug in your name and you'll see what's out there, either identical or similar to what you're trying to do. So that's a free search. We also offer that same access to that same database on our trademark website, flatfeetrademark.com. It's a free search that we encourage clients to use because we don't want clients to enter a name that's clearly not available before they place their trademark order, right? Because nobody wants to put in a name and say, well, there's an obvious conflict. Someone's doing this exact same thing in the, for the same exact products or services. So we encourage our clients to always do a knockout search. So that's something you can do on your own. It's free on the Trademark Office website or on our website to search the name you want. And what you're looking for is to make sure the name is not being used in connection with your same goods or services. So if you blog about beauty products or beauty consulting services, look to see, is someone using this for blogging? Is there someone using this for consulting in the beauty field? Is someone using this for cosmetics, right? Because that could be a problem for you. Now the search you do, this dog is so cute. The search you do on your own is just what's called a knockout search, right? Most lay people don't know exactly how to search, but you can at least do enough to get you past the first threshold, which is an obvious conflict. So you may need to do the second option, which is to hire an attorney to do it for you. So if you hire an attorney, obviously we know how to search differently, and we know the different things that could possibly trip up your application. One thing being variations. So we talked about Swirl and Swirl Wine Consulting. If you typed your mark in, it probably wouldn't show up on a trademark search, to be honest. You're gonna come back with no results. You wouldn't see anyone with that same exact mark. But there could be a variation that may affect your process or your ability to use that name. And that's where the nuances of trademarks come in, and could, and the trademark attorney can help you to kind of navigate some of those potential pitfalls that aren't necessarily obvious in the search process. So 2 options. You can search on your own using the free tools, or you can hire a trademark attorney. Keep in mind, if you search on your own, that is really just a preliminary step in the process. It's not going to be definitive that your name is available. Again, we just talked about the swirl example. That's an example where even if it shows nothing, you're not necessarily in the clear. And that's where an experienced attorney can at least guide you in the right direction as far as the availability of your name or your trademark. So once you've searched your mark, the next thing is filing to protect your trademark, right? The federal trademark application process at the US Patent and Trademark Office. Once you file your trademark, we had a question about the classes, right? So trademarks are organized into 45 different classes. Whatever you're offering is going to fall into one of these 45 different classes. The lady in the back mentioned that she's protected for clothing, sports apparel and fitness apparel. That's one class, right? That covers all the clothing things. Shirts, outerwear, jackets, footwear, headwear, as I said. Jewelry, though, is a separate class, so that's a second class. Leather handbags, purses and wallets, bags, duffel bags, sports bags. That's yet a third class. If you do insurance services, that's another class. If you do wine consulting, any kind of business consulting, that's yet another class. So whatever you're doing is going to be in a specific category. The Trademark Office charges a filing fee of $275 per class in which you want protection.
Not necessarily are where they are selling merchandise, that is basically putting their own sort of input on fashion or wine or whatever you're doing. What would the class be for me, who's a fashion blogger, who just wants to protect her logo underneath?
Right, so there is a classification for bloggers. We actually do quite a few blogging trademarks. So there is a category that covers blogs. Blogs, it's a more specific description than just blog. It's like providing a website featuring information about fashion, style, and travel. So the description is not necessarily obvious, but that's what blogs fall into. So there's a specific category for that. Now, obviously, when you're starting your blog, you know for sure you do blogging, right? You know for sure that's something you offer. You may not know yet what else you may offer. If you're going to launch a line of products or an ebook or a language learning software, that's something you can do down the road, obviously. So you might want to just start with protecting your blog if it's a business, right? As in the beginning, you may not necessarily have a trademark. If this is just a hobby, something you do for fun, you have no intention of turning it into a business, this may not be for you. But if you really are committed to turning your blog into a business, or possibly using it as a platform to launch a product or services that you get paid for, then you want to seriously consider protecting your trademark, right? Yeah, so the government filing fee is per class of goods or services. So you see how at $275 per class, it can get fairly expensive. If you want to protect yourself in 5 or 6 classes, you know, we have clients that call, they're like, oh yeah, I want to do mugs and t-shirts and keychains and bumper stickers and all these things. And you're like, okay, you know it's going to be $275 per class, right? And they very quickly back up like, okay, well maybe I only need one to start. You know, so, you know, the cost can get significant when you're looking at $275. And keep in mind, that's at least for our firm and almost everyone out there, the government filing fees, it's per class. So if you have one trademark in 5 classes, you're paying for each of those 5 classes. The legal fee is generally going to be per trademark. So you don't pay the legal fee per class, the legal fee is per trademark. That's just a side note. So once you've searched your mark and you're filing at the trademark office, we've talked about the filing fee that applies per class. The trademark registration process takes anywhere from 9 to 12 months to obtain registration. So once you file your trademark, it's going to be about 9 to 12 months before your mark becomes registered. Now, how can you file your trademark? There are a couple different options, right? So you can either file your mark as in use, if you're already up and running, which most of you, I think with the exception of 1 or 2 hands went up, you're currently in use. So if you're in use, you can file, your mark will go all the way through within 9 to 12 months and you'll just get to the end of the line. Trademark Office also gives you an option to file what's called an intent to use trademark application. So let's say you're not yet using your mark or you're not yet up and running with your blog, but you have a name in mind that you want to use and you want to get it while it's still available because your search shows that it looks pretty good. The Trademark Office lets you file an intent to use application. This is a way to get into line at the Trademark Office early, even before you're doing anything to protect the name that you want to use. Why is this important? Because 400,000 trademarks are filed every year. So a name that's here today may not necessarily be there tomorrow. So the intent to use option gives you the opportunity to get in line early. And reason being why you want to secure your place at the Trademark Office is the first person to protect or file their trademark application gets the presumption of priority before everybody else. So even if you've been blogging under your name for the last 10 years, if someone beats you to the Trademark Office, they're going to get what's called nationwide priority before you. And you have what's called prior use rights in your geographic region. So without getting too technical, if you're using your mark, you get geographic rights in that name in your area, South Florida, Miami, Florida, the entire state, wherever you can show you've been using the mark very actively or you have followers and clients and you've done business with the mark. But if someone files before you, they're gonna get the rest of the United States where you have not used your mark. So that's kind of one of the reasons why you want to get your mark in as soon as possible, to beat your competitors in case there's someone out there using a similar name. So the trademark process, as I said, takes 9 to 12 months. So during this time, if you're intent to use, you can start using your mark at any time. Right? You don't have to wait that entire 9 to 12 month period to start using your trademark. You can start using it any time during this process. Once you show use of your mark or file as in use, your mark will ultimately, hopefully, proceed to registration. So the object of all of this, right, is to get a registered trademark, a federal registered trademark. Why do you want a federal registered trademark? There are a number of benefits, right, to having a federal registered trademark. Main, primary, most important reason that's really most relevant to most people is they want to own their brand. Like you want to make sure the name you're using, you own it, you have full rights in it, no one else can stop you from using that name, no one else can come into your market wherever you're operating and tell you to stop it or to start using a competing name, right? So your federal trademark gives you that presumption of ownership. Second reason is investors, right? You may start off small, but as you're launching products or services, you find you need to bring investors on board. What's the first question a lot of investors are going to ask? Do you own this? Do you own your intellectual property? Anybody like Shark Tank in here? Like, I love the show Shark Tank. It's like one of my favorite shows.
Yeah, I love.
Right? So if you watch Shark Tank, they always are asking, oh, do you have your patents? Is it copy? Do you have your copyright? Do you have your trademark? This is something that investors want to know, that not only because you own the brand, they want to see how committed you are to making that investment, make the investment. or business portfolio that are valuable to investors. So that's another reason. There are also statutory benefits to having a federal trademark, right? As I said before, you get some rights in your name just by using it. So even without seeking registration, you do get some rights in the name. That being said, a federal trademark, you don't have to prove as many things as you have to prove just by using your mark. If you have a federal trademark, you can send someone a letter and say, boom, here's my trademark, stop using my name. If you have just use rights, you then have to say, well, I've used it here and I've used it there and I started it this time and I've been using it before you, so you need to stop. And they're going to say, well, yeah, that's not very scary because it's very difficult to enforce or show use of a what's called common law trademark. So when you have a federal registration, it is literally just a single weapon you can pull out. I hate to use that pun, but it's pretty much something you just pull out and say, hey, look, I have this, you need to stop. And most people do comply and do listen because it's quite a powerful tool. So that's another reason. The statutory benefits are things that most people very rarely encounter because very few people come to the point where they have to file a federal lawsuit, at least most small businesses. You get to sue for triple damages. You get to, register your mark with customs, so infringing goods can't enter the country. So there's statutory benefits as well, but most people find that the true value of their trademark is to prevent other people from using that name in connection with similar goods. So I'll take a pause because they're serving, and then I'll also let you guys ask me some questions in the meantime. What's the right time to seek your trademark or to try to protect your trademark? And the short answer is it really just depends, right? It depends on what you're going into your blog, what's your purpose behind your blog. Is it just a hobby? Is it just something that you're doing for fun that you're like, okay, I just want an outlet to write and express myself and share my thoughts? Some people go into blogging that way, or they go into the mindset like, I'm going to make a business of this. Blogging has become like a career. Like there are people who have built businesses and brands out of blogging. So it just depends on how you're approaching, your blog and your brand, and also your budget, right? So whether you do it yourself, you can certainly, DIY, or you can hire an attorney. So it also depends on your budget because it does take an investment. Even if you DIY, right? We talked about $275 being the filing fee, but there is a certain amount of investment. Depends on your brand name. Obviously, once you start posting and you start getting some traction, you might say, oh, this is getting big, I need to protect it. So it really just depends on, the individual person. I always tell people, do it as soon as possible because I can't tell you how many clients call us and say, oh, I've been using this mark for the last 5 years, and someone else just started using it and they applied before me. And so it's like as soon as possible, but it's not necessarily for everyone. So it's kind of a hard question to answer. Because you hate to be caught in that position of someone using your name after you've already established it, but that's kind of how it goes. So as soon as possible, but it really just depends.
So you said your brands are descriptive, so they wouldn't be as strong. My blog is called From People's Blog. Would that be too descriptive? Would that be?
It depends on what you're offering, right? So Paula's question was, I'm sorry? I'm going to repeat the question. Yeah, her question was descriptive trademarks. Her blog is Coral Gables Love. Is that a descriptive trademark? And it depends on what you are offering. What's your products or services?
Influencer marketing for labels. I have a business directory for businesses. Pretty much marketing for labels. But I'm doing it through my blog, which has my audience. And I talk about what I love about
Yeah, not necessarily, right? So the word Coral Gables, I talked earlier about having to disclaim descriptive content. So in a mark like Coral Gables Love, it's not necessarily a love site, right? It's not necessarily like a dating site or anything like that. So the name Coral Gables Love doesn't exactly describe what you do, right? But it does tell me that it's something about Coral Gables, or it does involve Coral Gables. So that part of her mark, I talked earlier about descriptive portions of your trademark, right? You can have portions of your mark that are descriptive. So you probably have to submit a disclaimer of the words Coral Gables, right? So that part of your mark would not be exclusive, but together, Coral Gables Love, it combines to make a mark that may be sufficiently distinctive.
So me.
Yeah, so one part of it is definitely descriptive, but altogether it's not necessarily descriptive. Coral Gables Magazine or Coral Gables Realty, totally descriptive. Coral Gables Love, yourself, not really, right? Because that's not a common phrase that we use. It's not something that we automatically know of. You know, it's something that you've kind of created that we wouldn't normally have heard before you use those three phrases together. It seems like descriptive trademarks is kind of a question, right? One little tip, one way to get around a descriptiveness trademark issue is to include a logo design. So there are marks that are descriptive that can qualify for trademark protection if you add a logo design. Because now what's protected is not just the descriptive words, Coral Gables magazine, but the look of the logo design that you've created, right? The logo that you're going to use on your magazine or on your website. So that's one way to help get past a descriptiveness refusal of the trademark office. So,
To do that, you should first trademark just your logo.
yeah, you can see if your mark is anywhere close to being descriptive, and what you really, really want that name, you don't want to change your name, you can include a logo design, and that can usually help to get you over the threshold. Because now what you're protecting is not just the phrase, but the look and feel of the entire design. Yeah. So, okay, we just talked about refusals, right? I used the word, you get a descriptiveness refusal. So we talked about your application being filed, we talked about the government filing fee. Your application goes through this process, it's 9 to 12 months. At some point during the process, there's going to be an examiner assigned to your trademark file, and this person's sole job is to look at your mark and determine whether it's a yes or a no. Is it going to be registered or is it going to be refused? That's all they're looking for, and there are a number of different bases that someone can refuse your application for. It could be that it conflicts with another mark, it could be that it's too descriptive, it could be that it's generic, right? The word escalator, that used to be a trademark. So if it's a generic mark, that could, result in a refusal. It could be that it's a surname. We see this sometimes. People want to trademark things with their last name. If your last name is Johnson or Smith, it's going to be difficult to get a trademark because it's primarily a surname. But if your name is Brown or King, these are examples of words that have other meanings besides just as a last name. So there are a number of reasons why the trademark office may refuse your trademark. So at some point during your process, you may get something called an office action. I see you nodding back there. Did you get an office action? Right. So if you submit your application, at some point in the process, you may get what's called an office action, which is a provisional refusal based on whatever reason. So the examiner assigned to your file will tell you why they're refusing the application. Descriptiveness, likelihood of confusion with another mark that's already pending or registered, a surname refusal, a geographic descriptiveness refusal, right? If you wanted to protect the word Havana for, guayaberas, they might say, oh, that's descriptive because, Cuba, guayaberas are associated with Cuba. So that might be a descriptiveness refusal based on geography. If you get an office action, it's not the end of the road. You do have a chance to respond and to present legal arguments or evidence as to why your mark should be allowed registration. So the trademark office is very, they do give you quite a few opportunities to get this process right, to fix any errors, to move your mark moving forward. Because at the end of the day, the trademark office really is a service for people to protect their brands, and they wouldn't have a business if they turned everybody away, right? Even though it's a government agency. Right, so usually I said that the process takes 9 to 12 months. Once your application is filed, it literally sits at the trademark office for about 4 months. No one looks at it until about 4 months. So somewhere between 4 and 5 months, an examiner is going to look at the application, and that's when you'll know if there are any issues with your application. He or she will issue this office action at some point between that 4th and 6th month. Once they have a chance to review it, do the conflict search. The search is important, as I said in the beginning, the most important step, because the first thing those examiners do is they're going to run a search of the trademark database to see what else is in here. Does this mark conflict with another mark? Is it too similar to another mark, for the likelihood of confusion standard? So that's the first thing that they're going to do, is to search your mark to see if there's a conflict. So the most common refusals we see are what's called 2D refusals, likelihood of confusion refusals. So they do search your mark, and your office action will come somewhere between the 4th and 6th month once you file. So let's say you've gone through the process, you've filed, you've gone past your office action, hopefully you don't get an office action. Your mark is going to go all the way through the process, and by the 9th to 12th month, the trademark office will hopefully issue your registration. So yeah, you now get like a certificate, you're like, oh, I have my registered trademark, and you're like, okay, now what do I do with it? People are like, oh, I want to get my trademark, but it's like, oh, now that you have your trademark, what do you do with it, right? It's important, and it's really up to you to enforce and maintain your trademark. What does that mean? you have to be proactive in protecting your brand name, right? And what does that mean? You have to prevent other people from using your trademark. I have a Google alert set up for my name, my firm, and my trademarks. So if someone, registers it or uses it or mentions it, I get an email to let me know that someone is using my trademark or my name, or I've been mentioned on the web somewhere. And so a Google alert is a great way to find out what's happening with your brand or your trademark name. So if you don't have one, I definitely recommend everyone set up a Google alert. Another way, obviously, you can also pay an attorney to monitor your trademark for you at the trademark office. So we do this for quite a few of our clients, where we literally monitor all the new filings at the trademark office to allow people to know, oh, someone has applied to register my same trademark, I need to do something about this. So the onus is on you as a trademark owner to protect and maintain your registration. You also have to continue using your trademark, right? Most companies go out of business within 5 years. So once you have your registered trademark, it's good for 10 years, but you have to file your first set of renewal documents between the 5th and 6th year after it's registered. Reason being, the trademark office wants to know you're still actually using that name. They want to see that you're still in business and you still want that trademark, or they're going to cancel your registration. So once your mark is registered, your first renewals are due between the 5th and 6th year post-registration, and then your other renewal, your second renewal, is due between the 9th and 10th year after your registration date. So it's within your first 10-year registration period, you have to file 2 sets of renewal documents. Right, correct. So patents are a little bit different in the sense that there is a limit on patents. I don't do patents, but I think it's 70 years or something, where after a while the patent will expire. Trademarks are renewable, 70. Trademarks are renewable indefinitely. So you can have a trademark from now on into perpetuity, as long as you file your renewal documents. Now, if you don't file your renewal documents, the trademark office will cancel your trademark. So even if you have it registered, they will cancel if you fail to file those renewal documents. So it's important that you maintain your trademark, use it, file your registration, your renewal documents. Monitor other people using your trademark, because the minute you allow other people to start using your trademark, a number of things happen, right? Your brand value starts to decrease. It's diminished because you now have competitors in the marketplace using your same trademark. We see this quite often with a lot of our clients who sell on Amazon. We have a client, he's got 10 trademarks. He sells everything from, nasal dilators to toys and, kids products. And, he does all these trademarks because the minute he files one, someone jumps in with a very similar trademark on Amazon to sell that same product under that same brand name. Because the idea is you want to start to sell those same products until Amazon shuts you down. And Amazon will do that if you have a registered trademark. They will shut down competing products that are selling under that same mark. But you have to be vigilant, because the minute you start, letting someone else use your trademark, it's going to be an open field for other people to start using your same trademark, and obviously it's going to diminish your value and your equity in the brand name. So you have to enforce your trademark and use it.
How about social media?
Yeah, so social media, this is a common thing that we see, right, with hashtags and social media campaigns. People want to know, if someone starts using my hashtags, it depends on if you have that hashtag protected for your goods or services, and it depends on how they're using it. So if they're using your trademark, your hashtag, or whatever your social media handle is, in connection with related goods or services, because of the likelihood of confusion standard, you could possibly go after them. So most people on social media don't use hashtags. Obviously we use it to be found, but we also use it a lot of times to promote our products or services. So you would be able to follow through to say, oh, this person is also using my hashtag to sell clothing. I need to do something about that. And that brings me to my next point, which are the different enforcement tools for your trademark. So I said you have to be vigilant, you have to watch what other people are doing, you have to use your trademark and file your renewal documents. How do you enforce your trademark directly against someone? You find an infringing use, what can you do? There are a number of tools available to the trademark owners to protect their marks. One of the first tools in your toolbox, is a cease and desist letter. This is kind of a warning shot to let people know, hey, look, I know you're using my mark and I want you to stop. So So it's a letter that you send to these other companies, these other users, to let them know that you're aware of their usage and you expect it to stop. If that doesn't happen, you then have to follow through with legal action from there, right? So that's one option, is a cease and desist letter. At the trademark office itself, you can also take proactive steps to protect your trademark. You can file what's called a petition to the director, a letter of protest. So this is a letter that you send to the trademark office to say, hey, someone has filed a trademark similar to mine. I think it's going to be a problem. You all need to be aware of this when you review the application. So when that application comes up for review within that 4-month period I talked about, they are already aware that you're out there and you want this mark to be shut down. So they will, if it's accepted, they will then tell the examiner assigned to the other trademark application, hey, you need to flag that trademark because it's too similar to Shahida's mark, for example. Okay, so your letter of protest is one option. At some point during the registration process, you have another option. It's called an opposition. So before that mark gets approved for registration, it's published for 30 days. And that's a period of time where anyone who's interested in that trademark can oppose the application. So we get a lot of big companies, Abercrombie and Fitch, DC Marvel Comics. These are companies that we've dealt with just within the last month. They have these attorneys that are literally watching the trademark docket, and they'll say, oh, this company has been provisionally approved. This application may be registered. We need to oppose this application. So at some point during that 30-day period, they can file what's called an opposition against your trademark. So that 30-day window is an opportunity for any interested third party, anyone, a common law user, a big registered company, to oppose your trademark application and basically shut it down. If you get an opposition, if you get an opposition, it's like going to trial. This company is basically suing you, but within the trademark system. It's not a federal lawsuit, it's just strictly within the trademark office. So it's federal in that sense, but it's going to go through the process within the trademark office. And so an opposition is yet another option. And of course, the last option, which nobody ever wants to do, is an actual federal lawsuit. It's very rare we see this for small businesses, but big companies have the budget and they're not afraid to file federal lawsuits for trademark infringement.
About the opposition. So have you seen it where somebody who has been using it, it's obvious that they've established that they're who's associated with that name, and then somebody just arbitrarily opposes it within that 30-day window, even though they don't have really any standing, they haven't been using it, another person has been?
Right. Yeah, with her question is, have I seen the case that someone who may not necessarily have any rights to the name, they'll just kind of file an opposition to prevent you from using that name. Okay, so as an initial matter, the fee to file an opposition is $300. So most people, unless you truly have an interest in that name and stopping that company from doing that, most people aren't just going to file an opposition just to file one because it's expensive. Okay, and it's, you know, like it's literally like starting a lawsuit, so you have to draft a brief, which is the equivalent of a complaint and a legal action. So most people are going to hire an attorney and pay that $300 filing fee. So it's not something that's a cheap thing to do. So most times if you get an opposition, it's going to be from someone who has a vested interest, whether it's based on their prior use rights, which are very difficult to enforce, so those companies very rarely win, but they do try. Or it's going to be a registered trademark owner that has the budget and the interest in protecting that name. So it's very rare you would see someone file an opposition just willy-nilly, but it does happen. And we've gotten some oppositions that are so ridiculous, like the marks are nowhere similar, but people, they have these attorneys who are very aggressive, and they're like, oh, let's sue. Because obviously the attorneys get paid, even though there really isn't a likelihood of confusion there. How much is what? The cost to seek a trademark? Yeah, well, it depends. One of the reasons we started Flat Fee Trademark was to provide an affordable trademark registration solution for small business owners, startups, and entrepreneurs, right? People contact us and they're like, oh, I spoke to my local attorney and he told me it's going to be $7,000. You know, why are you so inexpensive, or why are you so cheap? And I was like, well, you know, we have a different business model, basically. So the cost depends on who is doing the service. Our website, we're very upfront. It's $475 per trademark. That's what we charge. But there are also attorneys that charge by the hour, so you can pay up to $5,000, $6,000, $7,000 depending on who you're talking to. So we do it on a flat fee basis at $475. To be honest, it's something we do so many of them, we've streamlined the process. We have a set system where we get them, we turn them around, and we just get it done. Some lawyers, you're doing it like a one-off. They want to make as much money as they can from that file because they're only doing an application every now and then. They're not doing it kind of every day, many at a time, several at a time. No, I do have to make a living, so. No, I'm just kidding. No, of course. Yeah, it's $475 for the legal fee, and then $275 for the government filing fee per class. Very fair question. I get that all the time. I'm just kidding. Yeah, thank you. And I have to say, and I appreciate that. That is, when we started the company in 2008, we launched that new trademark in December of 2008. It was still kind of a novel concept, like the idea of hiring an attorney online. So even now, 8-9 years later, a lot of clients call and they're like, are you a real attorney? Am I talking to an attorney? Are you licensed? What's your bar number? So people are still very skeptical, but we've seen in the 8 years since we've been operating, a ton of companies jump into the fray. So there are quite a few companies now doing what we do, but a lot of them aren't necessarily attorneys, and they may not necessarily have been practicing trademark law for a long time. Because with everyone, now entrepreneurship is really a hot topic. There's so many people who have brands, who are launching brands, personal brands, business brands, products, services into the marketplace. The field for trademarks has gotten a little bit crowded, but I already have 12 years of experience behind my belt, so it does take, it's one of those things, practice makes perfect. So. Okay, great question. So whatever you submit to the trademark office, a couple of nuances here, and I want to help you guys, and I'll also answer general questions that you all may have about the process too. May's question is, if you change your trademark or you change your logo, what does that mean for your application? So whatever is submitted for registration is what's going to be protected. So if you make any changes to that logo design, you're going to lose some of your protection. If you change your name, you're obviously going to lose your trademark protection because you're no longer using that same name. And the trademark office, when you submit your application, they expect to see how you're using that trademark on your blog or on your products. So if you are doing cosmetics, whatever the trademark name that you submit, it has to be exactly as what appears on your packaging or on your box, or your label. So if you change that, if you submit one trademark for one thing, but you change even one letter, they'll say that's not acceptable because it's different than what you submitted. You'll have to reapply. Exactly. You'll have to reapply. You won't have to wait the whole time because, like I said, between the 4th and 6th month, you're going to know that there's a problem. So then you can either reapply. They're very strict that way. If there are any discrepancies between the name and the way that you're using it actually in commerce, they're gonna refuse it. So it's important that whatever name or design you submit is exactly the name or design that you plan to use on your products or services. We see this sometimes where clients will kind of, they'll come up with a logo really quickly to get, something submitted, but they ultimately end up changing it once they launch their company. That's not going to work because if it's different than what we submitted, the trademark office is going to refuse that application. Sure. Paula's question is, can you have different logos? Absolutely. Absolutely. It's whatever you use in connection with your products or services as your unique identifier. If it's the Nike, the word Nike, or the Nike swoosh, or the slogan, or if you have many different icons, you can protect all of them. There's no limit to how many trademarks you can file. Absolutely not. Of course, again, depends on your budget.
I wasn't sure if I heard you before correctly. When you said you submit your name with your logo, does that protect the name with the logo or the name and the logo?
Great question, and this was actually asked earlier, and I said I was going to address it. So, what's called composite marks, right? Shahida's question is, if you submit a name and a design, kind of what's protected. They're either word marks, right? So we have some word marks. That's just the word. That's the strongest trademark you can get. If you can just get your words. I would use her blog as an example, Deutsche Diva. If she just submitted those words, no design, no specialized font, nothing. If she gets that trademark, that's the strongest mark you can get because it doesn't matter how you use it, now or in the future with any kind of design, it's those 3 words, right? If you submit a stylized logo, if we think of, for example, Google looks like a word mark, but it's really a stylized design, right? They have the kind of very specialized font and that rainbow design. So that's an example of a word mark that's also a stylized design. And then there are marks that have both elements, right? They have a design element, you might see like a palm tree, and then something else kind of in the design. It has a graphic element to it, not just words. That's a composite mark. It has words and design elements. Whatever you submit is exactly what's protected. So if you have a design, if you change that design in the future, you're going to lose some of your protection. You may have to refile. If you submit a composite mark, they expect you to use those two elements together just the way you submitted it. So if we use an example of Nike and the swoosh, Nike has obviously all three elements protected separately, but also together. So if you have, Nike and the swoosh protected, you have to use it that way all the time. So for clients who want the freedom to use just the icon or just the word, we always tell them, hey, if you can afford to file them separately, file them as two separate marks. So you'll have protection for the word Nike and you'll have protection for the icon. You can use them together or you can use them separately.
I have two questions. I filed for intent to use. So I filed for intent to use. So I'm going to receive another application, or is it my responsibility to go on and fill something out?
Intent to use.
Yes.
Right, so I said earlier there are two bases to file your trademarks, intent to use or in use. If you file your application as intent to use, in approximately 6 to 8 months, the Trademark Office is going to issue what's called a notice of allowance for your trademark. And that's basically a provisional approval that says, hey, you're good to go, you've passed a lot of the thresholds, but we now need to see how you're using this mark in commerce. So you're going to get my email or whoever your contact person is that you're going to use to do your application. You're going to get an email about this notice of allowance. Once you get that notice, you have 6 months to show how you're using that trademark or request an extension of time. So your mark is not going to become registered until you respond to that notice of allowance and send them some tags or some labels and tell them when you start using the trademark. So that is the difference between an in-use mark and an intent-to-use application. If you're in use, you'll go all the way through from start to finish within that set time. If you're intent to use, you're going to get that notice of allowance and you then have to make an additional filing in order to get through the registration. Yeah. The additional fee is $100 for the government filing fee, and if you need to seek an extension of time, let's say within that period you're not yet using the mark, you need another 6 months, the extension fee is $150 for the government filing fee.
As if I was using it already, and just...
If you were using it, when you filed...
I'm using the name, but not the design. Not until I have the clothes. I don't want it to be shown until I have the clothing.
Right. So technically you cannot... It would be fraud to say you're using your trademark if you're not actually using it, because the standard is use in commerce. So if you are not actually using the mark or offering your products for sale in the marketplace, you technically cannot submit it as being in use because technically it's not available in commerce at that point. But if you did file it in use, you would go all the way through without having to do that notice of allowance.
I have another question. Does everybody that has a trademark, does everybody need legal representation, or can someone, handle it on their own, or?
Absolutely, great question. Do you need legal representation to register your trademark? You don't need a lawyer to do anything. You don't need a lawyer to defend yourself in a death penalty case. You don't need a lawyer to do a trademark. You don't need a lawyer to do anything. But, like I said, attorneys do know how to search. Trademark attorneys, we know how to search. We know some of the common mistakes you can encounter in the process. So having an attorney does help to navigate, kind of to shepherd the application usually through without too many issues. But you don't need an attorney. You can certainly do it yourself. The Trademark Office does have all the resources on their website for you to do it yourself. All right, let me just double check my notes, make sure I didn't miss any other talking points. I have any other questions for now?
One more thing. I will be using, I filed everything together, the name with the logo and color, everything specific. I'm going to be using the logo by itself.
Right, so her question is, she filed her logo and name all together. She wants to know if she wants to use just one part of the trademark, would she be able to do that? Yes, you can, but you're going to diminish some of your trademark rights. And let me explain how that happens, right? Let's say you submit a mark like the Nike swoosh. We'll just use Nike and the swoosh as an example. And I hate to keep using Nike, but we all know it. It's so common. Right? So the mark you submit is Nike and the mark, the swoosh together, right? And you want to just use the swoosh. The problem arises, so that's what will be registered. And you can definitely use that on your clothing and anything you want to use it for, that's in your application. The problem arises where there's another party that wants to register maybe just the word Nike, or maybe just something that looks like your swoosh design. They're gonna say, well, technically her mark, Vanessa's mark, is the word Nike and the swoosh design. That's her mark all together. It's one composite mark. You have to look at it all together. My mark is just the swoosh. It's just this one design. It's really different than her mark. You have to take her mark into consideration, both elements. And so that's where it becomes an issue. So would you be able to use both of them separately without having to seek the separate trademark? Absolutely. But if someone were to challenge your mark, your rights are then weakened because they can start tearing your mark apart, basically. Question in the back.
Add a logo later. How will you go about doing that?
Yes, certainly. So you don't have to submit a logo design. You know, I said you can submit a word mark. You don't need a logo design. And really a word mark is the strongest protection you can get. Because if you can get that word, you can adopt any logo design you want now or in the future. So you can certainly submit an application just for your words, you know, whatever your word part of your mark is, without a logo design. And if you adopt a logo in the future, then you would apply for that logo design if you want protection for the look and design of your logo. So you guys will see the Duffy's logo, right? Duffy's, I'm looking at it right behind me. It's a big D, small letter UFFYS with the sports bar and grill underneath it. That logo is protected exactly the way that it looks, right? That stylized design, the way that it's written. The word Duffy's is a part of the mark, obviously, but that's also protected. But when they register that whole thing together, it's really the way that it looks as well as the word part. Yes. That was on my list of things to talk about. Thank you for reminding me. I hadn't checked my notes yet. So, common question we get all the time. What's the difference between the TM and the R in the circle? The R in the circle, the short answer, is that's the registered trademark symbol. So you really cannot use that unless you have a registered trademark. So before you seek a trademark, before you seek your federal trademark registration, or while your application is pending, you can use the TM. That just kind of puts the world on notice that you're claiming a trademark in that name. But you can only use the R with the circle once your mark is actually registered. No, you don't have to use it, but most people, they want to show that they've taken that affirmative step, so they will use it, but you certainly don't have to use either one. And like I said, you do get rights in your name just by using it. It's just not as powerful as having it federally registered. Those are called common law rights.
That's your trademark.
Exactly.
Can you trademark your name?
Yes. So her question was, can you trademark your name? Carolina Herrera, if you want to use your trademark, your name as your trademark, you can absolutely do that. You can absolutely seek trademark registration for your name. Definitely.
Maybe I misunderstood. Earlier you said that it's your name. Oh, your surname.
Primarily a surname, correct. So if you just wanted to register the name Johnson, like I said, that may or may not be allowed because they may say, hey, it's just a surname. It's primarily known as a surname. And you can even get over it. I said, during your process, if you get an office action, you have an opportunity to respond to these office actions with arguments or evidence to overcome whatever that finding is. So even if you get a surname refusal, you have an opportunity to respond with evidence to show that, hey, it's not just a surname. Here are different ways that this name is used or how I've used it. So clients now know me as Johnson, it's not just a surname. People now associate this name with my products or my services. So you have different ways to get over these refusals.
What if you use initials and then a last name?
It depends on how the mark looks. But if it's, the initial part, if you're using, if it's just primarily a surname, like I said, you could very well get a surname refusal. Yeah. Which is different than using an entire name. And keep in mind, one quick thing about registering names, if your trademark has someone's name in it and it's a living individual, you have to have that person's permission to register that trademark. So a lot of people tried to, when Tiger Woods ran into all of the issues, a lot of people tried to register marks with the word Tiger. And without his approval, you can't register someone else's name. Obviously, that makes sense without their approval. take a quick pause. Let me just make sure I've covered all my points here. I think so. So yeah, so that's kind of my presentation on trademarks and the process. It's one of your most valuable business assets, depending on where you are. If you're small and just starting out and feel like you're just writing to yourself with your mom and no one's really listening, or if you're big and you're on the verge of launching a product or using your brand as a platform to launch your services into the marketplace, your trademark is definitely something you want to see about protecting, because it can be expensive to have to rebrand yourself. If for some reason you can't use the name you want, or you put significant goodwill and effort and blood, sweat, and tears into your brand name, and you have to rebrand, it can get expensive and it's a pain in the neck. So the sooner you can do it, the better for you, and obviously to build your brand strong in the marketplace. Yeah, that's it. And thank you guys again for having me. I really appreciate the chance to talk to you.
Can we give Serena another round of applause? Thank you so much for sharing all your knowledge with us. I learned so much today. So if you're interested in using Serena to register your trademark, she left some business cards here at the registration table. Feel free to keep it, even if you're not ready right now. Maybe in the future, then you'll know where to go.
And you can also just contact me with questions. I'm always happy just to talk to you and answer your questions, even if you don't have any.
We want to thank a couple of people that help us with the chapter, the South Florida chapter. Chapter officer May. You can blame it on me. We forgot to add your photos, but Liège, thank you. She's doing our Facebook Live. Anna, thank you. Kim, she's a photographer. If you're not on her Instagram, go harass her. Evie, who's not here. Diana, thank you. She brought Gabby with her.
No.
And Michelle is also not here. And then finally, a big thank you to Duffy's. Actually, they're going to bring us a few more dishes if you want to stay for lunch. If you enjoyed any of the food and you mind taking a photo and tagging them that you were here and they were awesome, they make sure we had all this space for us and they give us so much food. So if you enjoyed your gummy bear mojitos, make sure you tell the world, please. And let's see. Thank you. And then next month, it's going to be all about food photography. We're going to have a professional photographer giving you the best tips on taking photos with your iPhone of your food. So we usually all do it, even if we're just fashion vloggers. So that's going to be a good one. It's going to be at Macy's in Dayland Mall. And we'll be announcing that one soon also. So stay tuned. So feel free to stay and hang out.